Ready, start. It was mentioned therein that input tax credit on stock held as on 31/1/2014 would be restricted to the new rate of tax plus surcharge. Full stop. It was further clarified that the new tax regime would come into effect from 1/2/2014. Full stop. Respondent filed CWP number 7951 of 2014 before the High Court for a declaration that Rule 21 within bracket 8 of the Punjab VAT rules as inserted by the notification dated 25/1/2014 was ultra vires the Constitution and the Punjab VAT Act. Full stop. Contention of the respondent was that credit for the tax already paid by the taxable person on goods kept as stock in trade would be reduced by virtue of Rule 21 within bracket 8, which is illegal and unconstitutional. Full stop. By the impugned judgment, High Court allowed the writ petition holding that on the date of introduction of sub rule within bracket 8 in Rule 21 of the Punjab VAT rules, the state did not possess any power traceable to the Punjab VAT Act to confine the rate of input tax credit to the reduced rate of tax on the stock in trade, that is, on those concluded transactions where the taxable person had already earned input tax credit at the previous higher rate of tax. Full stop. Aggrieved thereby, the state is in appeal. Full stop. Learned counsel submits that the High Court was not at all justified in allowing the writ petition filed by the respondent, holding that on the date of introduction of sub rule within bracket 8 in Rule 21 of the Punjab VAT rules, the state did not possess any power to confine availing of input tax credit within bracket ITC bracket close to the reduced rate of tax on the stock in trade, that is, in respect of transactions that stood concluded with the taxable person already earning input tax credit at the previous higher rate of tax. Full stop. Judicial intervention in such a case was not warranted. Full stop. Referring to section 2 within bracket O of the Punjab VAT Act, he submits that input tax is the tax paid or payable in the course of business on the purchase of any goods made from a registered dealer of the state. Full stop. It is a tax in relation to a taxable person which is paid or is payable by him on the purchase of taxable goods for resale or for further use by the taxable person in the manufacture or processing or packing of taxable goods in the state. Full stop. Output tax, which is the tax charged or chargeable or payable under the Punjab VAT Act, extends the benefit of ITC subject to fulfillment of certain conditions. Full stop. Learned counsel submits that High Court has completely misread Rule 21 within bracket 8 of the Punjab VAT rules, holding that there would be retroactive application of the said rule, whereas no such intent is decipherable therefrom. Full stop. ITC is not a privilege but merely a facility to avoid the cascading effect of tax. Full stop. State government introduced the scheme of ITC under section 13 of the Punjab VAT Act to minimize the effect of VAT and to reduce the burden of tax on the ultimate consumer. Full stop. Every dealer within bracket taxable person bracket close calculates the output tax liability and reduces the tax paid on purchases to reach the quantum of tax payable. Full stop. Therefore, the state government has the power to impose tax at the stage of sale, and in certain cases, no ITC may be available. Full stop. A dealer would be entitled to ITC on the stock in trade held as on 31/1/2014, equal to the new rate of tax plus surcharge effective from 1/2/2014. Full stop. The goods purchased prior to 31/1/2014 and not sold or utilized till 31/1/2014 would be eligible to ITC at the new rate enforced till further sale. Full stop.